In this video, Mark, we're going to look at the concept of purported umbrella companies. This is an entirely new idea in tax legislation, and we're going to dive a little bit deeper into this umbrella joint and several liability legislation.
Matt, why don't you tell us how this works? And I've got to say, I don't envy your task.
Yes, it is it's a little bit down the rabbit hole, so you need to strap in for this part of the legislation. Very complex, very nuanced. It introduces some very detailed tests. I think this part of the legislation is actually potentially much more damaging, creating liabilities for clients and potentially agencies as well, more so than the umbrella legislation we talked about in the other video. So the way purported umbrella companies will work, this entirely new definition in the legislation, is split into three different cases. So I'm going to start with case one, the revenue case one, purported umbrella companies. The way that piece of the legislation will work is where there is a supply chain, the sort of supply chains that we're very familiar with, client, agency, some form of intermediary, and then a worker. But the worker is not actually employed by the intermediary, so it's not actually an umbrella company at all.
Okay.
But there's some suggestion, possibly with the client, possibly with the agency, that the worker is an employee. I'll go into that particular test in a bit more detail in a moment. Then PAYE will have to apply, and other parties will be jointly and severally liable. So to take a very common example, probably seen this recently reported in the press, where, for example, a client issues a diktat that everyone has to be PAYE, then the agency engages workers on a self-employed basis or uses an intermediary to engage workers on a self-employed basis. This is a scenario where this legislation is very likely to apply, because the test is if it's reasonable for HMRC to suppose that somebody at the client or the agency assumed the worker was an employee, then PAYE has to apply. So it's worth repeating that, because there's
please repeat it for me.
There's obviously there's quite a bit of detail and nuance in this. So it's where the client or the agency, as the case may be, assumes the worker is an employee, but they're actually not.
Okay.
So in that scenario, PAYE would apply. The umbrella company, the purported umbrella company, would have to deduct and pay PAYE to HMRC. If it fails to do so, then the umbrella company is liable for the PAYE, and the relevant party, be it the agency or the client, if it's a direct relationship, is going to be liable for the PAYE as well.
Okay, so we've got a scenario where the individual at the bottom of the chain is not being engaged as employed for tax purposes, and someone further up the chain, or it's reasonable to assume someone further up the chain, thought they were employed.
Yeah.
So does PAYE apply even if the individual at the bottom of the chain is correctly engaged as self-employed under other elements of the legislation?
Yes, absolutely.
Okay.
So this is, unlike the joint and several liability for actual umbrella companies, which is just a case of saying, well, the umbrella company is liable for the PAYE, their employees, PAYE should be being deducted. If the umbrella company doesn't do it properly or fails to pay it, somebody else in the supply chain is going to have to pick up the bill.
Yeah.
There's already PAYE due in that situation. This piece of the legislation, purported umbrella companies, creates an entirely new liability, because at the moment, nobody's operating PAYE because the workers are self-employed, for example. But if the client thought they were, employed, and it turns out they're not, this creates a new PAYE liability. They become like deemed employees.
Okay.
Suddenly the umbrella company is liable for all that PAYE. And if they're contracting with an agency who's contracting with a client, the agency is going to be liable as well. If they're direct to the client, it's probably going to be a less likely scenario, because the client ought to know how the people are being engaged. They're close to the intermediary, but It could happen that they think they're employed and they're not. In that scenario, the client will be liable for the PAYE as well.
Okay.
So it could be a potentially huge ruinous liability
Yeah.
created out of thin air, and all it needs is a supposition of employment.
Yeah.
And in fact, it's not even, that's putting it too highly. It's not even that. All it needs is for the revenue to reasonably suppose that somebody at the client would assume it's employment. So that decision, that impression is taken out of the client's hand. The client doesn't even have to think there's an employment. All it needs is for the revenue to say, well, it's reasonable for us to think you think there's an employment.
Wow.
So
Okay.
it's a double-edged test,
Yeah.
taking the decision entirely out of the client's hands. There's also another aspect to this test in the legislation as well, and that is if the intermediary, the purported umbrella company, does anything to give an impression of employment. So, for example, makes any representations up the supply chain to say these people are employed, and it turns out they're not. That also makes them a purported umbrella company. So PAYE will apply.
Yeah.
So basically, any impression of employment sent up the supply chain or sent down the supply chain from the client dictates to say these people have to be employed.
Yeah.
PAYE doesn't get operated. That's where this new aspect of the legislation kicks in and deems there to be PAYE, and all the usual joint and several liability provisions apply as well. So this is
massive.
This is big. Yeah. This is a really heavily onerous aspect of joint and several liability that's not really been focused on and discussed much in the tax press.
Okay, and I think what I'm getting from that is that what all the parties in the supply chain now need to do is be on all fours completely in terms of their communications with each other, their expectations of each other, and everyone needs to understand how the individuals are engaged so that those reasonable suppositions of an assumption can't be made by HMRC.
Yeah, exactly. We will do another video digging into the detail of that in much more depth, because it's really important.
Yeah.
As you say, clients know what to do, agencies know what to do, intermediaries and umbrella companies know what to do to avoid this potential liability. But the basic theme is transparency through the supply chain. You need to know how people are engaged, because the real risk is if somebody gets it wrong, somebody assumes one thing and another thing's happening. Out of thin air, there's PAYE liability on all the workers, which would inevitably run to tens, hundreds of thousands, millions of pounds even. And that liability is going to creep up the supply chain to the agency or the client.
Big then.
Big.
So I'm scared to ask, but you said there were two other cases. What's case two?
Case two is the scenario whereby people are engaged on a self-employed basis by an intermediary in a direct relationship with a client. So this will be the not uncommon scenario where a client decides, I've got all these self-employed people, rather than engage them directly myself, I can ring fence that risk. I can give them to an intermediary company to engage. So I'm buffered, I'm protected from the employment liabilities, from the PAYE liabilities if HMRC decide they're actually all employees. This company will engage with the workers and operate their pay for me. In that scenario, from 6th of April 2026, the client will be jointly and severally liable for Section 44, as it's known. So other people will know this as the SDC test, the test where if you engage somebody on a self-employed basis, you have to show there's no supervision, direction or control over the manner of their work. And if you can't do that, PAYE has to apply. This brings the client squarely into the realms of liability for that. So if the SDC test can't be met, then obviously PAYE is due, as it is at the moment. Intermediary one, as they call it, the party closest to the client, is the liable party. But from April, the client will also be liable. So the client now has a huge stake in making sure that the SDC test is met and you can show there's no supervision over the manner of the work. There's one exception to this, and that exception is where the intermediary found the client. So this is what you might think of as an agency exception. So if you're dealing directly with an agency and that agency is engaging the workers, if the agency found the client, then this case 2 purported umbrella company rule doesn't apply.
Okay.
But where the client provided the intermediary with all the workers, can you engage all these operatives for me? This legislation is squarely in point. There might be perhaps some benefit to this, bringing the client into liability. The upside might be that everybody's now more focused on getting that SDC test right, because we found in dealing with HMRC inquiries, if there's a problem, it's usually because there's something gone wrong at the client side, some handbook that's been issued, some site instructions that have been issued, something that's put a dent into the SDC test. But with the client now being potentially liable as well, hopefully there's a bit more due diligence and a bit more focus on getting that test right.
Okay, so just to summarise my understanding from what you said, we're now going from a scenario where under Section 44, ITPA, intermediary 1 is the liable party, and the ability to pass that liability on under Section 44 is quite limited, to a scenario where under Case 2 in this new legislation, HMRC's ability to make the liability stick further up the chain, likely with the end client, is significantly boosted.
Absolutely. Basically both parties are now liable in full for Section 44. And again, unlike the pure umbrella company legislation whereby PAYE is already being operated, it's just a case of making sure it's done properly and it's paid over, which is still a risk, but not as great a risk as this. In this scenario, this is a conversion of everybody from self-employment. Possibly CIS has been deducted if it's construction, but possibly not if it isn't. CIS or self-employment to PAYE, with all the liability significant in amount. I would imagine that entails creating this liability out of thin air and imposing it on the agency and the client.
Including employers' national insurance?
Including employers' national insurance.
Okay.
I should stress that the SDC test still remains. So if you can pass that, if you can show there's no supervision, direction or control over the manner of the work, you can still be self-employed. But if you can't pass that, now as the client, you potentially have a very large risk. Okay.
And just, I think because obviously the potential liability here being created out of nothing is huge, might just be worth recapping on the exemption you talked about with regards to where the intermediary finds the workers for the client, just so everyone's clear on that.
Yes. So the basic rule is, if you're intermediary 1 supplying workers to a client, you're liable for Section 44. If you can't show the SDC test is met, then you're liable and the client is now also liable as well, unless you found the client for that particular worker.
Okay.
If you found the client for that worker, so if you're an employment business providing work finding services to workers, then you're outside of this Case 2 purported umbrella company provision. But if you didn't find the worker, and that's going to be the scenario where clients use intermediary companies to engage all their self-employed workforce, I think that's the target of this particular case of purported umbrella company, then that exemption doesn't apply and joint and several liability applies instead.
Okay. So that's cases 1 and 2.
That's cases 1 and 2.
If we've got the stomach for it, shall we go to case 3?
Let's see if we can get through case 3.
Fair enough.
This is the scenario where there is a personal service company.
Okay.
Ordinarily, personal service companies, a company in which the worker has a material interest, would be outside of the umbrella legislation generally. But there's a specific rule that's introduced for those types of entities. And that rule, it's very similar to case 1 in concept. That rule says where somebody in the supply chain thinks that a substantial proportion of the payment is going to the worker as PAYE, as earnings, but it turns out that isn't the case,
Okay.
then PAYE is due on the lot.
Wow. Okay.
So in practical terms, we're going to be talking about a scenario really where a client has issued an SDS, for example,
Yeah.
and said, we think this worker's caught by R35, they're working through their own personal service company, you should be deducting PAYE. If that doesn't happen, then the personal service company is liable for the PAYE, and so are parties up the supply chain on a joint and several liability basis. It's probably going to be an agency, because that's the most common supply chain: client, agency, PSC, worker. But if it's direct to client, again, it's going to be the client who's a liable party. So that liability could come back through joint and several liability up to the client as well. Again, there's another provision, and that's where the PSC has given the impression that PAYE is being operated,
Yeah.
and it turns out it hasn't. Then
Okay.
this provision will apply as well. Case 3, purported umbrella company, PSC will be liable for PAYE on everything, and that liability will pass up the chain to the agency or directly to the client, as the case may be, under JSL, joint and several liability.
Okay. So I'm going to take a guess here, given cases 1 and 2 and the wide-ranging new concepts with no detail that HMRC have produced. Do we have any detail from HMRC on what substantial proportion of amounts paid to the PUC means?
We don't have any.
Okay.
We don't have any detail from HMRC on what the
surprised.
substantial proportion means. But I think in practical terms, we're either going to have a scenario where there's a PSC and maybe a small salary and everything's being paid out as dividends because they're outside of R35 or consider themselves to be, or they're going to be inside PAYE and everything's being deducted under PAYE anyway. So you tend to get to extremes with PSCs. But in the scenario where the client thinks it's at one end of the spectrum and it turns out to be the other, then this legislation will apply, and there'll be joint and several liability.
Okay. So, yeah, as we said, purported umbrella companies down the rabbit hole.
Definitely a much more convoluted, complicated, detailed, nuanced area of this legislation.
Yeah.
One that creates liabilities where they didn't exist before, which I think is really, really important. Still sends them up the supply chain to the other relevant parties. I think this is going to be the bigger problem from April. And again, just like with umbrella companies, you need to know exactly how people are engaged. You need that transparency right through the supply chain.
Yeah.
You need to understand what's happening. If you don't, it could be at your peril.
Right, Matt. So clearly, the purported umbrella company test is huge. So I'm going to set you a challenge now. 3 key points for our viewers, and only 3.
And only 3. I'll do my best. This is a really difficult one to distill into sort of bite size and manageable concept because it's just so complicated. But if I had to boil it down to 3 key points, I mean, the first and probably the most obvious one is to understand your supply chain, how people are engaged. Unlike previously, where you've got self-employed people, where you've got umbrella company workers, where you've got PSC engagements, you need to know exactly what's happening and what's being deducted. If you make a mistake here, potentially creates a liability. If you don't understand, potentially creates a liability. I think once you understand that supply chain, we will do separate videos for clients, for agencies, and for intermediaries on exactly what you need to do due diligence wise. But you certainly need to be looking at your contracts, because liabilities don't just flow from tax legislation, they flow from warranties and indemnities as well.
Okay.
So they can get passed around the supply chain. And then outside of the contracts, you need to be doing due diligence on the sort of interactions you have with umbrella companies. Because if there's a client at the top of the supply chain saying employment, and there's an intermediary at the bottom of the supply chain engaging people on a self-employed basis, that mismatch creates a massive problem in this world of purported umbrella companies, and it could be the parties in the middle that get caught out because they could be the ones jointly and severally liable, even though they're not involved in either of those two issues. So it really is a case of understanding what's going on in the supply chain, how people are being engaged, and making sure that theme runs all the way through, everybody understands and everybody's on the same page.